Good afternoon, ladies and gentlemen, and welcome to the second episode of the Legal Clinic. So today we'll be discussing the role of traditional authorities in the modern legal system. And as usual, we have our August guest with us, lawyer Mohammed. So without much ado, we dive into the first set of questions. So, Counsel, you're welcome.
Thank you.
Thank you for joining us
It's been another good day.
Oh, yes. So today we are discussing the role of our traditional authorities in the modern legal system. Now, when we talk about traditional authorities, what exactly are you referring to?
Okay, thank you for the question. And briefly, we look at our chiefs.
Okay.
Some people call them kings, some people call them the rulers or whatever. But they briefly, even the opinion of a family is a traditional authority. And even the Mbrantehene, traditional authority. So all this group of people come together to form traditional authority. The chiefs or the kings or the rulers, the Busuapeni, the Mbrantehene, the Ohema, all of them, they are part of the traditional authorities in the communities.
Okay, thank you so much. So now that we've established what the traditional authorities are, previously, what role did they play in our traditional system?
You see, before the common law became common law, the king sent a group of people to sit as judges, okay, in the communities, and these people did not adjudicate based on legal provisions, but based on traditional norms and customs of the people. That was what they used to adjudicate. So gradually, as they do those adjudication with their own set of rules, the traditions and norms, then it became the common law, the common thing that applied to the people. So traditionally, they adjudicate. Earlier on, they were giving judgments in terms of marriages and land disputes. Sometimes even when it comes to childbirth, when people deny ownership of children, traditional authorities come in to establish based on their own way of testing the father of the child. So, to be frank, they played a bigger role and they still play.
Okay, so currently, are they legally recognized under the Ghanaian law?
Okay, by virtue of Article 11 of the Constitution of Ghana, the laws of Ghana, we have customary law as part of the laws of Ghana. And customary law is the law of the people that developed by way of their custom and tradition. So if earlier on there were traditional authorities that were ruling, that were adjudicating based on tradition and customs, and now it has become part of the law, then we say that still they play, the law finds a place for them.
Okay, thank you very much. So per this submission, what I'm getting is that, for instance, the customary law in Kumasi may not necessarily apply to that of Accra because of their customs and their way of life. Is that what you mean?
You are right. You are right. Even when it comes to marriages, because the Ghana customary law on marriage is a bit different from that of the Fanti, different from that of the Akan, and or the Achim, and that of the Ashanti, and even the Kwans. So they are even the northern region. Custom law on marriage is a bit there's variation, but they all have a common point at which they converge. That is why the law of Ghana recognizes them as part of the laws of Ghana. So long as whatever you are doing, it does not contradict the Constitution. Article 1, 2, Constitution says that anything, whether act or law or provision, whatever, that contradicts the constitutional provisions to the extent of the inconsistency is null and void. So it means that if you are organizing a program in your custom, and then part of it aligns with the Constitution of Ghana or the laws of Ghana, and part does not align, it doesn't mean the whole thing is a nullity. Sure. It is the portion that does not align. That is what we cut off from what you are doing, and then the remaining that align will proceed. That's what we call to the extent of the inconsistency it's not employed.
Okay, thank you so much. So, in essence, it means that all the laws in Ghana, no matter where you find yourself, no matter your tradition, it must conform to the constitution.
Fantastic.
Okay, thank you so much. So, how do these traditional authorities contribute to modern governance as it is now?
Okay. Sometimes, you see, if you look at, for example, Section 7 of the ADR Act 2010, Act 798, and then Section 64 of the same Act, Section 73, all these provisions, they talk about reference of matters before the court that are amenable to mediation and arbitration. And this mediation arbitration is not necessarily court-related one. It can be to traditional rulers.
Okay.
To be opinion to maybe the chief or to whoever to talk, to mediate or to arbitrate, to come to understanding. Then the court is informed. So they contribute by virtue of these provisions. Even the Court Act also makes a provision for certain matters that are amenable to, even if it's criminal, and amenable to mediation or arbitration, to be sent for that. I give example of a case that we are doing.
Okay.
I won't mention the court name, and I won't mention the parties because of the confidentiality of the provision. In that case, the chiefs who were grantors of the parties in litigation brought a letter to the court asking the court to allow them to mediate between the parties so that they will resolve the matter and bring the feedback. And the court obliged them. So it tells you that traditional rulers are also currently part of the modern legal system.
Okay, as they are part of our modern legal system, what are some of the limitations or challenges that they face?
Very good. All the provisions I've mentioned, they talk about the fact that even if the matter is released to the chiefs or to the Bushapin or whoever to resolve, it does not end there. Whatever is done, the court must be informed of it in writing. So the court will adopt that settlement terms as what? Consent judgment. So this is a limitation on the authorities of the traditional council. Because if, for example, there's no limitation, like the moment the matter is released to you, the court should be functus officio. Functus officio means the court should have ended its work. But it doesn't end there. You need to go and do something about it, come and inform the court. So if it's resolved, the court will be noted. If not, the court will note it. When it's resolved, the court will adopt it as consent judgment by asking the parties, is it what you agreed at the chief's palace? Is it what you agreed at the Bushapin's house or wherever it was sent to? If they say yes, the court say by this, I adopt it as consent judgment. If it wasn't resolved, then the court must give further orders as to how the matter must proceed in the court. So to be frank, there's a limitation. Because if the limitation is not, and I agree with the limitation, because I have an experience again in that direction where a certain category of people who came to were given the opportunity to resolve a matter. But when they were, what they were doing is as if they were taking stands. So if there was no limitation, like whatever they had done would not be fair and just. For the limitation, whatever they had done, when the matter comes back to the court, and the court finds from the parties, did you take part? Did you agree with everything? If they say yes, then fine. If not, the court will put all what they have done aside and proceed with the matter.
Okay, thank you very much.
You're
I think
welcome.
we need to have a thorough discussion on ADL.
Fantastic.
We would love to do that with you one day.
And I'm not bragging. I had A in ADR at the law school.
That's wonderful.
My master's program, I had A in ADR.
Wow, excellent, excellent.
And Lawyer Haji once told me that I've won my certificate in ADR.